Marriage, Common Law, and Divorce. Part 2. Marriage and Legal Implications. Marriage is governed by federal law but administered by provincial authorities. It's highly recommended that couples entering marriage consider a prenuptial agreement, marriage or domestic contract. This outlines how assets will be divided in case of divorce. It can help avoid disputes and protect specific gifts, inheritances, or property from becoming matrimonial property. If there is no agreement and the marriage breaks down, property division will follow provincial family law. Legal advice is always recommended in such cases. Common law relationships. Common law status is a provincial matter, except when it comes to federal income tax. Federally, if a couple lives together in a conjugal relationship for 1 year, they are treated as spouses for tax purposes. Provincially, for example, in Ontario, a common law relationship is recognized after 3 years of cohabitation, or less if children are involved. Quebec does not legally recognize common law relationships. A cohabitation agreement or domestic contract is often recommended. It functions like a prenup and protects each party's property and expectations in case of separation. Rights and support. Regardless of whether a couple is married or common law, child support is a federal matter and is mandatory by law. Spousal support is typically governed by provincial law, but federal guidelines may apply. Divorce. Divorce is also governed federally. You must be divorced before marrying again. Property division after divorce is provincial. During divorce, life insurance policies can be subject to property division. For example, the cash value of a universal or whole life policy might be split. The death benefit is not considered family property and is treated like a gift or inheritance. So, cash value equals potentially divisible. Death benefit equals protected, especially if going to a named beneficiary, not the estate.